Estate planning is a topic we put off because we don't want to face the music. Wills and trusts protect our assets and make sure our assets are distributed according to our wishes. This is a complex topic, and we have asked the McIntosh Law Firm in Davidson to explain how wills and trusts can help our families. Today, we have Amy Isaacs and Erika Erlenbach to answer our questions. I want to thank both experts for being here today. Welcome to the Financial Self-Defense Show on Channel 4. I'm your host, Joseph Russo. Welcome to the show. Here we are with Erika and Amy from the McIntosh Law Firm in Davidson. I want to thank you very much for coming in today.
You're welcome.
Let's just go over some of the details of Amy. Her areas of concentration are wills and trusts, including living wills, powers of attorney, estate planning, probate, and business corporate law. And Erika is real estate, also in her area of concentration, as well as wills and trusts and estates. Thank you very much. Let's start with some questions for Amy Isaacs. Amy, is a will really necessary?
Absolutely. If you're an adult living in North Carolina, or any state for that matter, regardless of how much property you may have, a will is imperative. A lot of people have the misconception that a will is necessary only if you own lots of property, if you have an estate that might be subject to taxes. However, a will is going to be important for any adult person in the state because it may dispose of your assets in the way that you wish for your assets to be disposed of. It can also contain provisions for guardianship for minor children in case you leave children behind. So it's not all about the money. It can also be about non-monetary things like placement of your children or nomination of executors or trustees for trust named under your will. As a matter of fact, some estates can be quite small by dollar standards and run into all sorts of problems if the deceased person does not have a will. And so the sad irony is that a lot of the estate assets could be depleted, paying attorneys and other professionals to clean up the messes that might be made as a result of not having a will.
Because they have to go through the probate process?
Well, because you may have to go through additional steps with the court that you don't have to go to if you have a valid last will and testament. If there are minor children involved, then there are even more steps involved, and a lot of these things can be avoided by having a will that nominates a person to care for the children, a person to hold assets for the children, and so it can save so much time and money just to have a valid last will and testament.
If you have any situations where you have pets involved in an estate fight, I'm sure
pets can share as well. North Carolina specifically allows for a trust that can be set up for your pets. And so a lot of people are surprised to hear that. But
I am, because we're concerned about that.
I think that anymore people are making choices not to have children and not to sometimes leave things to their children even if they have children. And pets are very important to those of us that have them. We think of them as little people and members of our family.
Absolutely.
And so North Carolina recognizes that.
So there's actually a trust set up for pets.
You can absolutely set up a trust for your pets.
My wife's going to love to hear that.
We've done it. And people have set up trusts for dogs and cats, parrots. I actually learned from a client that a parrot can live to be upwards of 75 years old or older, and I didn't know that until we got into setting up a trust for parrots.
Are wills complicated to set up, or do attorneys just make them complicated?
Gosh, let me see. I need to answer that the right way, don't I?
You have to do that.
A will does not have to be complicated. It absolutely does not have to be, and I would strongly urge folks to work with an attorney when setting up a will, and working with an attorney does not necessarily make it complicated. There are complicated attorneys everywhere, but certainly working with an attorney is not going to complicate the process. Working with a trusted and competent attorney is going to help you get those questions answered that might not get answered if you were to just go on the internet and pull a form off the internet.
That's my next question, because there's a lot of, you could just get a lot of this information right off the internet.
Well, my advice is if you're going to do an online will, make sure you have online support or an attorney who can answer
Which they
questions.
usually don't give you that support.
You don't get that.
Right.
And the problem is there's nobody there to prompt you with questions that you might not have thought about beforehand.
Right.
And if you're working with an attorney who concentrates in this area and has a lot of experience and has pretty much seen what can happen if things don't get done right, then you may be prompted to consider situations that you never in a million years might have considered had you tried to go it on your own.
So basically it's personalization and make sure that every T is crossed and I is dotted.
Exactly.
Absolutely.
That makes perfect sense. Erika, what happens when a parent or both parents die and there are minor children involved? I'm a little confused because I know they have the age of minors, 18, 21. What is that situation?
It's 18. In North
18?
Carolina, the age of majority is 18 unless they've been emancipated by the court. And if
Does that happen often, by the way?
Emancipation?
Yeah.
No, not often. It
think
can
so.
happen, but it's uncommon. So 18 is really considered the legal age of an adult. And that's important because, as Amy had discussed about previously, if you're dealing with guardianships, if you pass away and you don't have a will where you've named a guardian, the court's going to name someone. That may or may not be the person you would have chosen for that child.
Right. Plus, I know that can get very costly. When I was up in New York doing appraisals, I was involved in a couple of custodial cases, and it was very expensive.
It is very expensive. And you also have to consider that there are assets typically involved with an estate. Oftentimes, those are intended for the minor child, and if, again, there is no will, depending on who the heirs are, if that child is an heir, then that's something else you need to consider, is that somehow those assets are going to need to be managed, and the court's going to have to find somebody to do that.
So all this management can be taken account for in the will.
Absolutely.
Okay, this way a guardian can be appointed. Does a court have to approve a guardian?
Yeah, what happens in the will is you would put the person that you would choose, and even an alternate person. Ultimately, the court is going to approve or disapprove that person that you would have named. And Amy, you can talk a little bit more about that as well. But basically, if there isn't a good reason not to have that person be a guardian, the court is typically going to go with the person you would request.
Let's talk about the mechanics just a little bit. Does a will have to be notarized? And we've seen X's on, you see all the stuff in the movies, you have a little X and a witness. Is that good enough, or do you have to have notarization of a will?
It depends on the kind of will. If it's a holographic will, then you do not. If it's
what is a holographic will?
Handwritten.
Okay.
If it's a validly signed and attested will, then yes, it does need to be notarized.
So if it's a handwritten will, a deathbed will, is that what they call it? A deathbed will?
No, it can be. It doesn't have to be. Yeah.
Handwritten will does not have to be notarized, and that's a valid will.
That's a valid will.
Okay, it's a valid will.
It's valid if it's in the handwriting of the person making it and signed by them. The problem that I've seen, the practical problem that I've seen with the handwritten or holographic will is, again, it was made without sitting down with somebody who could really walk you through the process.
So there could be a lot of defects in that will.
There can be gaps. There can be things that don't get addressed. And what happens is the rest of your estate that's not disposed of or addressed by your handwritten will still passes according to the law of North Carolina of intestacy. Intestacy is what you have if you don't have a will.
Well, this is very interesting. We're going to take a short break, and we'll be right back to continue this conversation. Thank you very much.
The wait is over. Introducing the MyConnection Triple Play. When you add MyConnection voice service to your cable and high-speed internet, you'll save a bundle. MyConnection voice is as low as $35 per month. Enjoy crystal clear local and long-distance calls anywhere in the U.S. and Canada. MyConnection voice delivers over 15 of the most